Welcome. I was going to say good morning or good afternoon, but it's really just a good noon. Welcome to the Bench and Bar Committee's Lunch and Learn program. Everything you need to know about Section 341 meetings. My name is Cece Schnapp. I am law clerk to Chief Judge Wendy Hagenaut, and I'm also chair of the Bench and Bar Committee. So I'm delighted to welcome you here today. I will give a brief introduction and a few remarks before handing it over to our esteemed panelists. Today the program is all told an hour. We are going to leave a little bit of time at the end for questions. So I ask you to please hold those until the end, as I anticipate our panelists may already answer your question before we get all the way through. And a quick reminder that this program and all of our previous presentations are available on the court's website. If you go to the main website, ganb.uscourts.gov, and go to attorney information, there's a Bench and Bar tab. And under the Bench and Bar Committee tab, you will see all presentations. Our first one was back in 2017. And so you will see not only the slide decks, but also links to the recorded seminars. So it's a great resource. I highly recommend you check it out for our information on all things from lien avoidance to tax issues to today's presentation, of course. So without further ado, I would like to introduce our panelists. We have Mike Barger with Roundtree, Liebman, Klein & Geer, LLC. He is a partner with the firm and a Chapter 7 trustee. We have Lauren Drayton of the Summerhead Law Firm. She regularly represents consumer debtors and will bring that perspective to the panel. Maria Joyner of the Office of Nancy Whaley, standing Chapter 13 trustee. So she will fill us in on all you need to know from the Chapter 13 trustee's perspective. And finally, Janine Treese with the Office of the United States Trustee. So a quick just kind of run through of the agenda before I pass that off to our speakers. We are going to talk about what is a 341 meeting, the parties involved in the meeting and the roles and responsibilities of those parties, what to do to prepare for the 341 meetings, best practices, and then we'll open it up for questions at the end. So with that, thank you very much for coming, and I am pleased to pass it off to Janine. Thank you.
Sorry, unmuting. Good morning or good noon, everybody. I'm Janine Treese. I'm with the Assistant United States Trustee for the Northern District of Georgia. And before I start talking, I have three things I wanted to say. One is something I'm required to say, which is my statements are my own and not necessarily the position of the United States Trustee. The second thing I wanted to say was thank you to the Bench and Bar Committee for inviting me to speak to about a topic that is near and dear to my heart. I'm real protective of 341 meetings, and the reason is because 341 meetings are the responsibility and province of the U.S. Trustee. And so what I would like to do is to encourage you, if you have a question about 341 meetings or a comment or a concern or a request, please address those to me. And I'd be happy to help you with those rather than filing a pleading with the court. We generally can work everything out if you'll just give us a call and let us collaborate and communicate. So with that, I'm just going to start talking about what 341 meetings are. I'm sure everyone here knows that the meeting of creditors under Section 341 is the official forum where the debtor must appear and answer questions under oath about the debtor's business and financial affairs. Questions are posed by the trustee and creditors and other parties in interest, and the debtor's attendance is required, and that is pursuant to Bankruptcy Code Section 343. Rule 2003 sets the parameters for scheduling meetings and tells the U.S. Trustee when we have to schedule the meetings. So in Chapter 7s and 11s, that's no fewer than 21 days and no more than 40 days after the order for relief. And in Chapter 13 cases, it's no fewer than 21 and no more than 50 days after the order for relief. Technically, the U.S. Trustee presides at the meetings of creditors. In cases under Chapters 7 and 13, the U.S. Trustee delegates that responsibility to the trustee. And in Chapter 11 cases, the U.S. Trustee's attorney conducts those meetings. The U.S. Trustee and her designees have the authority to administer oaths, and that's under the bankruptcy rules. The business of the meeting generally is to examine the debtor, and also in Chapter 7s can include the election of a Chapter 7 trustee. And if that's another thing we really do appreciate getting a heads up is if you're a creditor and you intend to call for an election of a trustee, there are a lot of procedures and things we have to do. So we really do appreciate getting a heads up for that. All meetings must be electronically recorded using equipment provided by the United States trustee. The standing trustee or case trustee is responsible for ensuring that the recording equipment is operating properly, that parties speak clearly, and that testimony is being recorded, because we have a responsibility for maintaining those recordings and making them available to anyone who asks for them. The trustee, after the meeting, is required to promptly submit or file a report of the result of the meeting, whether it was concluded, continued, or rescheduled. Also, the U.S. trustee is authorized under Bankruptcy Rule 2003-F to call a special meeting of creditors on request of a party in interest or on the U.S. trustee's own initiative. Debtors must, as I mentioned, attend the meeting of creditors. Rule 2005 permits the court on application and affidavit to order the debtor apprehended to compel attendance at the meeting of creditors. And we have had to do that in this district from time to time. I wanted to mention that under General Order 2-2005, upon the Chapter 7 trustee's request for dismissal of the case due to non-appearance, the clerk of court is directed to enter in an order dismissing the case without further notice or hearing. If a debtor's attorney fails to appear, the trustee may either continue the meeting or proceed with questioning the debtor. Generally, the better practice is for the trustee to reschedule the meeting because we want the debtor to have the debtor's attorney at the meeting. Unjustified failure of an attorney to appear warrants the request or motion under 329B to compel a refund by the debtor's attorney. And typically those come from our office, the U.S. trustee's office, via email, usually from me, asking for a reduction fee for failure to attend. This next section is really important. I want to talk about special needs of debtors. Individuals who have limited English proficiency may seek assistance in order to participate in the meetings of creditors. The program offers free telephone interpreter services. I want to remind you that neither the trustee nor the trustee's employees can serve as interpreters, and neither can family members, friends, the debtor's attorneys, or debtor's attorney's employees. We want a disinterested person serving as the interpreter. Our teleinterpreter and services offer translation of more than 250 languages. But if you become aware that your client speaks a rare language or dialect, please let us know ahead of time so we can make sure that that language is provided for by the teleinterpreters. The trustee will place the interpreter under oath in accordance with the rules. And I wanted to also let you know that effective September 1st, the program is using a new teleinterpreter and service. The procedures are mostly the same, but please be patient with the trustees while we adjust to this new service. There are a few differences, so you might notice a little bit of hesitancy or delay while we get used to this new procedure. If you become aware of a debtor's physical disability, such as a hearing impairment, please notify my office immediately. And obviously, this is something that should come to your attention as you're performing your intake services. So we'd like you to please contact us immediately after the case is filed. We will consult with you and the trustee to determine what reasonable accommodations can be made. The accommodations and procedures are tailored to the debtor's specific situation. And that is why it's very important to notify us immediately so we can assess the situation, figure out what the needs are, figuring out what appropriate accommodations we can offer. Also, it's very important if we make accommodations, especially for an American Sign Language interpreter, for example, that you let us know if there's some reason the meeting is not going to go forward, because we have to pay for the ASL interpreter every time they appear. So if if you don't appear or debtor doesn't appear, we have to pay for the interpreter anyway. So please let us know if there's some change that needs to be made. And sometimes we've had situations where people don't speak sign language, and we have developed case-specific procedures. So just again, let us know soon as you know. Moving on, the Bankruptcy Code, Section 521 and Rule 4002 list information and materials that the debtor must produce in connection with the 341 meeting. First, remember, please, that at least 7 days prior to the Section 341 meeting, the debtor must submit a copy of the debtor's most recently filed tax return. This is one of the most common referrals that our office receives from trustees, is the debtor's failure to produce the tax return 7 days before the meeting of creditors. And please note that failure to produce the tax return is cause for dismissal of the case unless the debtor has a really good excuse of why he or she was unable to do so. The U.S. Trustee Office in the Northern District of Georgia has published a guidance paper regarding the production of tax returns, and it's on our website. We really do expect debtors and debtors' attorneys to comply with this request. It causes a lot of problems, a lot of delay in the case. We have to continue meetings. Trustees have to fill out forms when the tax return is not provided. And I'll tell you, my first question is, of course, why? And when did the debtor's attorney collect it? So sometimes we prosecute or request reduction in attorney fees when the tax return is not timely provided. Otherwise, we will also move to dismiss the case. In addition to the tax return, under Rule 4002, the debtor is supposed to bring the following materials to the 341 meeting: photo identification, proof of Social Security number, evidence of current income, such as the most recent payment advice, and statements for each and every depository and investment account that includes the petition date. Obviously, we're not in in-person meetings anymore, so the best practice is to get those materials to the trustee ahead of the 341 meeting. Moving on to the scope and conduct of the meeting. The trustee is expected to administer an oath to each individual debtor and not group swearings. The scope of the meeting of creditors is very broad. The trustee is going to examine the debtor to the extent appropriate to verify income, to determine the existence and value of assets, to identify transfers, particularly fraudulent transfers, to review exemptions, to discuss prior filings, and inquire into other matters. There are certain required questions, the mandatory questions that the U.S. trustee requires be asked at every single meeting of creditors. The current list of those questions and additional suggested questions are on the program's website. There is a little bit of variation between the Chapter 7 questions and the Chapter 13 questions. But they're free, they're public information, and they're free for you to have and review with your clients so they will know what to expect at the meeting. The trustee, of course, is required to verify on the record that the debtor is aware of the consequences of seeking a discharge. The debtor is aware of the ability to file a petition under different chapters, the effect of receiving a discharge, the effect of reaffirming a debt. These are things the trustee is required by law to discuss with the debtor. And in this district and really everywhere over the country, we accomplish this by the debtor reviewing the bankruptcy information sheet, which you provide to your client. So rather than going through all of those in detail, generally the trustee will ask the debtor if he or she has read the bankruptcy information sheet. And that is why that question is asked, because it has all that information that the trustee is required to impart to the debtor. After the trustee's completed his or her examination of the debtor, the trustee must inquire if there are parties in interest or creditors who wish to ask questions. Parties are allowed a reasonable amount of time to ask questions, but cannot turn the examination into a Rule 2004 examination. Individuals who represent a creditor but who are not attorneys may be present at the meeting, and generally these people are allowed to examine the debtor. Trustees are expected to conduct the meeting in an orderly yet flexible manner. They are required to exercise control over the demeanor of the participants. Uncooperative or recalcitrant debtors are to be reminded of their duty to cooperate with the trustee. Trustees are not allowed to give legal advice to debtors or creditors, and we remind trustees that they must avoid actions that would result in the perception that the trustee is a judge or has judicial power. For example, the meeting must be referred to as a meeting and not a hearing, and I will tell you that's one of my pet peeves. Representatives of the media are permitted to be present, but no one is permitted to electronically record the meeting other than the United States trustee, the trustee, or a certified court reporter. That's another thing that we would like a heads up on. If you are going to have a court reporter attend the meeting, I need to know about that ahead of time and make arrangements with that person. No one is to televise, make videotapes, or photograph the debtor or any other party at the meeting. Lastly, virtual meetings. So earlier this year, the program announced plans to implement a new permanent policy to conduct meetings via Zoom video conference, in cases under chapters 7, 12, and 13. Obviously, the video meeting has several advantages over telephonic meetings, including providing visual verification of identification, demeanor, and credibility, preserving the evidentiary value of the testimony, and retaining the formal and public nature of the meeting. We understand that there will be needs in limited special circumstances for meetings to be in person. And so the trustees will have discretion to continue a virtual meeting to an in-person meeting, usually with the U.S. trustees' approval, if there's a specific issue that needs to be addressed in person. And there will also, we understand, be situations where a debtor will not be able to participate by video. And so we will be able to continue to allow telephonic appearance as well in appropriate situations. We are piloting the video meetings in Region 10, which is Colorado, Wyoming, and Utah. And after we finish doing that, we will be able to roll out the meetings in other regions after we've figured out what all the issues are and what procedures we need to implement. We will be conducting training ahead of time. So just be on the lookout for that. And I will be sending out notices when I have more information on that. Thank you for your attention.
Thank you, Janine.
I think, Bree, you are looking at me. I think this is my cue. So the question here is who conducts the meeting? I'll let Maria address the Chapter 13 side, but the Chapter 7 meeting, the United States trustee appoints a panel trustee to reside over the meeting, and the trustee conducts the meeting, as you all know. Prior to the meeting, the Chapter 7 trustee will, or one of his or her employees, will have reviewed the petition and the related documents. And you all know that the job of the Chapter 7 trustee is to liquidate assets for the benefit of unsecured creditors. In my office, we will have also reviewed all of the and publicly available information. We review GSCCA, we look at ECC filings, we review Georgia real estate records to see if there are any undisclosed real estate interests. And when we are conducting the meeting, as Janine just mentioned, we record it. I always make an announcement at the beginning of the meeting that I am recording the meeting and I'm the only one who should record the meeting. And we used to, in the old formatting, we used to make very general announcements, but in today's world, we only have 10 minutes to conduct each meeting. And so in the Chapter 7 trustee side, we are not making general announcements any longer. And we call a meeting every 10 minutes. And I do my best to stay on those 10-minute increments. I've got lots of funny stories about debtors who randomly call into the meeting and actually just start participating in the meeting right in the middle. And so if you could all, if you're a debtor's attorney, if you could advise your client that we try to start on the 10-minute increment and that they should not just call in and start participating. We will call their meeting by name and by case number at each 10-minute interval, that would be much appreciated so that we don't need to miss. This is where folks are answering questions on behalf of other debtors, et cetera.
Well, I'm Maria Joyner, and I will talk a little bit about this from the Chapter 13 side. So in Chapter 13 matters, there will be either the standing trustee or a staff attorney of the trustee that's going to conduct the meeting of creditors. Generally, we're going to go through the petition schedules, the documents required under 521, such as the pay advices, the tax returns, the identification documents. And so in a Chapter 13, it is a little bit different that we are looking at a Chapter 13 plan. So we're looking at the administration of the plan and also, the ability to be able to collect the payments from the debtors and make distributions to creditors. So we do have, I'm going to go through sort of who are the Chapter 13 trustees, and then Mike is going to go through the Chapter 7 trustees. So we do have 3 Chapter 13 trustees in the Northern District of Georgia. There is Ed Zafir, Melissa Davey, and Nancy Whaley. And then you can see listed there the judges. So the judges are all, I guess the trustees are assigned to different judges. And Mr. Zafir's office handles the Atlanta and Rome divisions. In Melissa Davey's office, the Atlanta and Noonan divisions. And then in Nancy Whaley's office, it's Atlanta and also Gainesville. Each of the different trustees have staff attorneys, and you can see the listing of the staff attorneys. I won't go through who all the staff attorneys are, but I will say that in addition to the list of staff attorneys in Nancy Whaley's office that's on this slide, we actually have a brand new attorney to our office starting today. Her name is Lisa Bardman Burnett, and we're very excited to have her with us, and we hope that you'll all get to meet her soon. So each of the trustees does have a website, and there in each trustee's website will have several links to different things that you may need. Some of the things that are provided through our website are information about business cases, links for different ways to make payments. There's a debtor resources tab and an attorney resources tab. So if you haven't ever looked at the trustees' websites, I highly suggest that you go to those because they may have information that would help you, help you instruct your clients. There's a note here at the very bottom of the slide about identification documents and tax returns. And as far as what you should do prior to the 341, this is probably the most important information that I'm going to give you. And that is provide the identification documents and the debtor's last filed tax return to the trustee at least 3 days prior to the scheduled meeting. And all 3 of the trustees in the Northern District of Georgia accept those documents the same way. And that is on a portal. It was formerly called 13 Documents, and now it's Bankruptcy Documents. We really, really request that you do not send those by email, but actually upload them to the portal. And make sure that you do that at least 3 days in advance of the meeting. One other note that I have about what's on our websites. So for Nancy Whaley's office, as well as Melissa Davey's office, you can find on the website copies of the 341 calendar. Usually they're up there a couple of days prior to that day's meeting schedule. And for Ed Zafir's office, those will be on NDC. So if that helps you to have those calendars in advance, you can find them on the websites or on NDC. And there's also another document that, went too fast. So for Chapter 13 cases assigned to Nancy Whaley, we do have a debtor questionnaire that is to be completed and filed on the docket prior to the 341 meeting of creditors. And you can find that PDF, a fillable PDF of that on our website if you don't already have a copy of that.
So you all know, unlike the Chapter 13 trustee, Chapter 13 trustees, Chapter 7 trustees are assigned geographically. And so there are 10 of us now in Atlanta, and I don't pretend to know an expert on the history of the numbers, but I think that is significantly lower than what we have had historically. I think maybe 15 to 18 has been the historical number. There are 2 in Gainesville, 3 in Newton, and then two in Rome. And each trustee uses different software. I, for example, use Stretto. Other trustees use KCC, Epic. There are lots of others. So I don't need to only list that's just the ones that I know of. And each of us would like if you would upload the documents 7 days before the meeting, and also use our document management software. I think Maria's point is well taken, at least on the trustee side. It is a colossal undertaking to just manage all of the documents and information that we are required to get in from you all. And so that these systems allow us to do that efficiently and quickly. And if you just reach out to each of us, we will be happy to tell you how we prefer to receive documents from your offices, and you can just pick up the phone and call or email. We'll be happy to point you in the right direction. The one thing that Janine mentioned earlier, and I'd like to point out, is that the rules do require that you produce the financial account statements for each financial account that you have, that the debtor has on the petition date. I will say that I would say we're probably shooting 5%. That's a pretty bad free throw percentage. And it's certainly bad as far as producing to us the documents that we need. And we do look at those because it tells us how much money is in each bank account, each financial account on the petition date. It also identifies any potential preferential transfers, et cetera. So we do ask that you comply with that. I think technically we could probably reset the meeting. And in fact, I think we could ask that the case be dismissed. I don't know that any trustee actually does that, but just as a bar practice, it would be nice if folks would comply with that requirement. And we also look at real estate files, et cetera. And so you will get individual requests from us. I know that the United States Trustee's Office, the executive office, has kind of a best practices. Then they limit what we are allowed to ask for. And they ask that we only make special requests in idiosyncratic circumstances. For example, if we identify a new car purchase, then we are permitted to ask for title records, et cetera. Or if there's been a real estate transfer, we may ask for the HUD one. And don't be afraid to pick up the phone and call and ask what we need. If you think you have a special circumstance that may give rise to additional documents, don't be afraid to start the communication lines. That always goes a long way.
So I guess, Mike, you talked a little bit about the call and the announcements in chapter 7s, that they're generally, it's not sort of a large general announcement anymore, since the meetings are on every 10 minutes. For chapter 13 currently, we are doing meetings on the half hour. There are 3 per half hour, generally starting at 9 a.m. on days that we do meetings of creditors. And there will be an introduction at that time. Generally, you could say that I will state my name and remind people to keep their phone on mute when they're not actively in their meeting, remind people to speak up loudly and clearly because of the recording, and remind folks to stay in a quiet place during their meeting, if at all possible. And I do generally, I don't say it in my general announcements, but if I realize that someone is actually in fact driving, I will ask them to stop driving while they're doing their meeting, because it's just not safe. Also, if there are joint debtors, I'll have to say either in my remarks right before their meeting or in the general meeting that both will need to state each answer on the record. And it's also nice if they sort of stagger their answers rather than saying it at the exact same time, because it does make a clearer recording. If the debtor does not appear, so there are a couple of reasons that we would not be able to hold the meeting of creditors. One, obviously, is either the debtor or debtor's counsel not appearing at the 341 meeting, or the failure to file a Chapter 13 plan prior to the meeting, or not having the identification documents provided to the trustee prior to the meeting. So for any of those reasons, those may be reasons to request a reset of the 341 meeting. And you can do so at the meeting. And if the meeting is going to be continued, then the trustee will announce the reset date. There will be no further notice on the docket or sent out in the mail of the reset date. And it's important to definitely listen out for what phone line the reset date will be on. Generally, it's going to be on the same phone line, but there are times where that's not possible. Each Chapter 13 trustee has 2 phone lines. So it's always important to make sure that you're calling in and have the correct access code. And especially that the debtors are calling into the right line and are provided the correct access code. So with resets or continuances, just make sure that you have that information.
And on the Chapter 7 trustee side, we always use the same telephone number and the same passcode for each of our calls. And so our resets will be same telephone number, same pass lines. Reminds me of the old Batman, same time, same channel, I think. And so we will reset for similar situations, no tax return, failure to file schedules within an appropriate time, a reasonable time before the 341 meeting, such that we haven't had a chance to review. There's a difference between resets and continuations, and there's all kinds of codes that we have to know that we enter in when those things are filed with the clerk's office. Like Maria, when there is a joint debtor, I always say, in an ordinary situation, it would be fine for one of them to answer, and that would be, fair communication. But when we're taking down the record, we do need them both to respond to all of the questions. And like Maria, it is always nice that someone does not have their head out the window while they're participating in the 341 meeting. I think there are stories of folks sitting in a fast food drive-through, ordering while they're conducting, or while we are conducting the meetings. And I know it's a very convenient. In fact, I would say this is anecdotal that participation has been better since we've moved these meetings to the telephone line. But I say ordinary telephone decorum. Don't drive while the debtor is while we are conducting the meeting with the debtor. Try to be in a quiet place. I know a lot of these folks are still at work while they're doing these, and they try to relegate themselves to quiet rooms. But if they can do that and do their best, then it's much appreciated. It goes a very long way.
So after the announcements at the 341 meeting, generally we will swear the debtor in, have the debtor be sworn in on the record. And then we're going to look at the identification documents. And there are certain statements that need to be made by the attorney for the debtor on the record about those identification documents. And I've put them on this slide, and I'll say that it is, I can certainly ask each of those questions at the beginning of the meeting after the attorney puts their name on the record. But it's wonderful when people already know the statements to make and are prepared to just go ahead and make those statements on the record. So one, that the identification documents have been personally inspected by the attorney, that attorney that is on the line. Also indicate the names of the documents that have been reviewed and provided to the trustee. So is it the driver's license, social security card, W-2, state on the record the documents that were reviewed and then provided to the trustee. Indicate that the identification documents appear to be valid documents that identified the debtor, the person who is speaking on the line. And confirm that the information on the identification documents matches the name of the debtor and the identification number that appear on the notice of meeting of creditors. So generally, we're looking for you to let us know if there's some issue that the social security number is not matching once you've reviewed this. You definitely want to bring that up. If there is a different address for the debtor on the debtor's driver's license, it's always helpful to note that so we can confirm that the address on the petition is the correct address for the debtor. And so being prepared and reviewing these, I believe Lauren's going to go through some practice pointers on this, but it is a really important part of the process. And at any point, even during this point, if you feel that the person that is speaking, that has started testifying, is not the person whose identification documents you've reviewed, please speak up and make sure that that you put that on the record, because obviously from the Chapter 13 or Chapter 7 trustees perspective, you're the only person that's going to know that's on the phone line at that time.
I think that's a great point, Maria. We have never met these folks, and not that you all should be experts in recognizing voices, but any help that you can provide is much appreciated. We again don't know that the person who is speaking is the person in most instances, and I actually ask an affirmative question: are you the individual who filed this bankruptcy case, before I start every one of my meetings? And so if you all identify or sense anything out of the ordinary, if you could speak up, that would go a long way.
Sure. So we went through to put together a sample of questions at a 341 meeting. Some of these are going to be in a Chapter 7, some are going to be in a Chapter 13. I think the majority of them are kind of in both. Now they're not, so each staff attorney and each trustee, and I'm sure the Chapter 7 trustees, are not necessarily going to say the questions in this order or say them the exact same way, but the information that is going to be asked of the debtor is going to be similar. So we're going to sort of hit the highlights of some of these, but for anyone who is wanting, to make sure that their clients are prepared for the 341 meeting, the next couple of slides you'll see are sort of an example of examination questions that you could certainly prepare your client to see. So the first couple, I know in a Chapter 13 meeting, are going to be making sure that the debtor understands what's in their Chapter 13 plan, schedules, and statement of financial affairs, and that those that they met with an attorney that assisted them in preparing those things, that everything is true and correct, and that all of their assets and debts are provided. And then we generally ask about credit unions and credit union loans, and then also about child support or alimony. If you know that someone is has a child support obligation or multiple child support obligations or alimony obligations, it's important to prepare them for the 341 so that they know that question is going to come up. Mike, do you want me to go through from the Chapter 13 perspective and then you go back and fill in?
Well, yeah, however you want to handle it. I think Janine pointed out, I did not know this, but we have different required questions depending on which chapter you're in. And what I would encourage you to do is just go to the United States Trustees website and read the Chapter 7 required questions. Like Maria said, they're essentially, did you provide the information, your schedules, to your attorney? Was the information true and correct? Is it true and correct today? Have you had a change in your financial circumstances? And I say the same exact things. I may not get them out in the same order if I get distracted or if some issue comes up, but I tend to say the same things over and over and over again. And, just the biggest point from my perspective is these are never trick questions. We are asking them because we are required to ask them. And the more you can coach your client to know that these are not designed in any way, shape, or form to play gotcha with the debtor. This is really requirements, and there should be a very obvious answer if things have been done the right way. If they've not been done the right way, though, we need to know that. We need to know why. Get to the bottom of it. But yeah, Maria, I don't know if you want to just go through what you all would ask, like kind of backfill from there.
Sure, I'll just sort of go through some categories. I'm not going to read through each of the questions, but we do ask about retirement accounts and contributions to retirement accounts. We certainly verify the debtor's current employer and the income that they're making, the income in their household, whether they're married, single, whether they have dependents. And I know in the Chapter 7 context, they're going to ask the question about whether you have read the bankruptcy information sheet provided by the United States trustee. I know, and then there's certainly going to be questions about real estate, whether the debtor owns real estate, has sold or transferred any real estate. If the debtor does own real estate, we're going to discuss or ask questions about the mortgage and the homeowners association, the value of that asset and any liens that are against that. And one thing that I think that I get where maybe the attorney doesn't know about it, or one of those things that kind of happens at the meeting is during my question of, have you sold or transferred your interest in any real estate in the last, two years? And that is where I think information comes up more often than any other section of our questions that maybe has not been discussed with the attorney. And it's very important that all the real estate is disclosed. Maybe there's been an inheritance, or really they inherited the property from someone with siblings. And oftentimes people will bring that up. So I hope that that's a question that, everyone's asking their clients prior to the meeting. We do ask about prior bankruptcy cases, and also look at the tax return. If the tax return is not provided before the meeting in the chapter 13, we will still hold the meeting, but you will have to provide an affidavit that the tax return is true and correct once it is provided to the chapter 13 trustees. So it's much better to have that provided prior to the meeting.
We kind of run through the same thing. And, the one thing that's interesting, just anecdotally again, is, kind of the misunderstanding that folks have about whether they own real estate or not. I think a lot of folks think that because they have a mortgage against their home, that they don't own it. And I always go, I say, I'm not giving legal advice, but there's a difference between equitable and legal title passes, et cetera. And so the coaching that the debtors attorneys can do on that side would be very beneficial. Again, we are relegated to 10 minutes for each of these. And so we don't have a lot of time to get into the nitty gritty on a lot of the things. And we will continue if we need to ask additional questions. And if tax returns aren't there, we will also, Chapter 7 trustees will also conduct the meeting, but we will continue the meeting and require that the debtors produce it to us, and then actually have them come back and ask them under oath. Again, I guess Maria is accomplishing it through an affidavit. We accomplish it through sworn testimony that it is a true and correct copy of the most recent return that they have filed. And so, I think these things always go very well. I think that the debtors bar does a great job in getting us the information that we need. And it's really just kind of the one-offs where things don't go the way that they should. But a lot of the big surprises in the Chapter 7 trustee world are, well, you own the home where you live, and we'll get pushback. No, I don't. And we'll have a copy of the deed into them that shows clearly that they own legal title. And so, those are not necessarily problems that we're going to solve during the 341 meeting. But in my mind, that the debtors bar should have at least looked at GSCCA before they file. I know sometimes it's hard to figure out if you own Blackacre in Alaska, that's not necessarily an easy thing to figure out. If the debtor owns the home where they live, that should be something that should be discovered before the 341, at least in my mind.
Well, let's see. So in a Chapter 13 or at a Chapter 7 meeting, this part is just for Chapter 13s. We do go through the plan and the claims that have been filed, and look through the set payments and special provisions. And we are looking to debtors counsel to confirm that, that we have things set up as is anticipated by the Chapter 13 plan. Also in Chapter 7 or Chapter 13, creditors can attend, and announce any claim that they may have, and can ask questions of the debtor that, is pertinent to the debts or the assets in the case. Generally, there's a fine line between allowing that to go on too long in order that, as Janine spoke about earlier, that really a separate examination needs to be provided for. But for the most part, that is an opportunity. It is the meeting of creditors for them to ask questions about their collateral or about the debts or the income in the case.
Maria, have you noticed a difference in your cases? Are you getting a lot more creditors showing up? I thought for sure when we went to telephonic meetings that we were going to get calls in every meeting. And I think, at least in my experience, I feel like we've had fewer creditors show up at meetings than when we held them in person versus telephonically.
Yes, I do think it has been fewer. I agree. I don't know how many people are listening in on the conversation, because I know in person, oftentimes people were there in the meeting room, like listening to the answers, not necessarily making an appearance in the case. So I'm not sure if that's still happening. We just don't know it, but I have not seen as many creditors there. Well, we'll try to quickly go through. Oh, well, I'll let you go through this. I know we need to let Lauren get to their information.
Really important point. So a lot of folks don't realize, but Chapter 7 trustees have affirmative duties beyond just conducting the meeting. For example, we are required by statute to send out letters to every domestic support claimant before the 341 meeting or within a reasonable time of the 341 meeting. And then we also are required to send out discharge letters too. So, I think somebody mentioned the other day that somebody had 15 domestic support obligation claimants. So that's $7.50 of mail, at the first 341 meeting, and then $7.50 of mail at the discharge. And so it's very important that the debtor provide the address of anyone with the domestic support obligation claim. And what you see there in the PowerPoint is the form that we will ask you to fill out. You should have this if you represent debtors regularly. If you do not have this form, just email one of the Chapter 7 trustees or the Chapter 13 trustees. We will provide this form to you. And then we also have forms that they gave to us that used to be in the meeting room. You used to see up on the wall. They're all the printed copies of all of these things. And we have those electronically. So if you think that you need them, don't be afraid to reach out. But if you don't have this form, please reach out to me. I'll email it to you. But please upload this before the meeting. And also this information should be included on the debtor's disclosure forms on Schedule EF, or Schedule E technically, but Schedule EF is what we call it now.
And this will be in the materials when the materials are uploaded to the website for this program as well, not the slide, but the actual PDF document. Okay, so I guess in Chapter 7 and 13 cases, sometimes we do designate cases as business 341s. Is there anything you want to say about that, Mike?
Yeah, I think in the Chapter 7 context, if the most important thing, obviously, when you file a Chapter 7 corporate debtor, the business needs to cease prior to the filing. The debtor should not be operating, and we appreciate the debtor's bar, doing the heavy lifting. If the debtor needs to operate, pick up the phone and call and let us know that. I think I've had 1 or 2 cases over the last 12 years where someone thought the debtor should operate. And so if you think that is the case, please call. We also would appreciate any heads up if the debtor has its books and records stored on a cloud program. In my mind, that is something that should be disclosed on Schedule G. I think that's an executory contract that should be disclosed. And a lot of these cloud storage systems, if you don't pay the fee, they will destroy the books and records. And that makes it very hard for us to do our jobs. And so if you know that those books and records are stored on a cloud system, just pick up the phone and call. Let us know about E&O insurance. And then also, make sure if you're filing a Chapter 7 corporate case that you actually have the right person signing the thing that needs to be signed to get them into the case. There's lots of horror stories where there is no corporate authority. A Chapter 7 trustee goes out and sells something, and it turns out that they didn't have the right to do that. So all the right to sell flows through the right of the filing. And so just confirm those things. And if there's any question in that regard, please let the Chapter 7 trustee know so that they can do their own due diligence and confirm that there may or may not be an issue.
And in Chapter 13 cases, you'll either, if once we review the schedules and the petition, if we determine that there's a business being operated that is, I guess we sort of look at the complicatedness of the situation as to whether or not, the amount of income and expenses, whether there's employees, whether the debtor is incorporated, assets, debts, in the name of the business. So for those, we may request one of 2 things. We may just send out a business packet and ask for the debtor to complete that prior to the meeting of creditors, or we may send out a business packet and renotice the meeting of creditors to a date and time where we will have more time than the general, 10 minutes on the mass calendar date. So if you see any of those things, that means that, and if we send those out and it's really not a business case, really, it's kind of confusing on the schedules, feel free to reach out, to the staff attorneys to explain some of that information. And also, think about that when you're drafting schedules I and J or the statement of financial affairs. The more information you can provide to us, the better idea we'll have as to how complicated the business is, and hopefully not, reschedule the meeting or send out a business packet in a case where it's really not necessary. All right, so Lauren, we'll let you take it away. Thank you.
Hello. So when it comes to preparing your client for the 341 meeting, and I'll be saying client and debtor interchangeably. I know that not everyone listening to this has the debtor-client relationship, but I'll say both and mean the same thing. So you're going to want to prepare early and often. This preparation starts during the initial consultation and continues with the petition preparation. You're going to go over the basics of the 341 meeting, when it is, how it's held, courthouse, telephonic, Zoom, that it's mandatory and under oath, that the date and time will not be of their choosing, and that he or she is going to be personally questioned by the trustee. Once the case is actually filed and the client is assigned a specific 341 meeting, you can send the client the notice of the meeting of creditors along with any other documents like the domestic support obligation form, resend the bankruptcy information sheet, specific Chapter 13 payment information, and any appropriate questionnaires depending on the chapter and trustee assignment. So even though you'll have already discussed the 341 meeting, because it's a lot of information and clients can get overwhelmed or confused, the most helpful preparation will be done at the 341 prep call, when you'll be able to go into even more detail so they will be fully prepared. I say call because it's probably the easiest and how most firms handle it, but it could be an in-person or Zoom meeting as well. Now that we're doing telephonic calls or telephonic 341s, there are really two parts to the preparation call. You'll be talking about the legal aspect and then the technical aspect of how to handle the call itself, or when we transition to Zoom, how to handle the video conference. So you'll make sure that they have the correct date, time, call-in number, and code. I always ask clients if anything has changed since they filed, or if they noticed any errors or omissions on the petition before moving on to the questions that they'll be asked by the trustee, which were covered earlier. Make sure to tell clients to have the petition in front of them in case they need to refer to it. Let them know that creditors may attend, they typically don't, but what to expect if a creditor does appear. Make sure that they understand that while their attorney will attend the meeting, they will be answering the questions themselves. No one else is allowed to speak for them. Make sure that they know that the questions will take place under oath and subject to penalties for perjury. So it's important to be accurate and honest. If an interpreter is needed, make sure to let the trustee know as soon as possible. As one of the earlier slides noted, the Department of Justice has the bankruptcy information sheet in over a dozen languages on their website. If they do need an interpreter, make sure they're aware that the trustee may use that initial 341 meeting to reset the actual meeting to a later time or date to make sure that he has the time needed to actually conduct the hearing. If the prep call takes place over a week before the 341 meeting, it's a good time to upload the documents to the trustee and also to request any missing documents from the client. Another thing to ask, health and safety permitting, especially when the 341 meeting transitions to Zoom, is whether or not the client needs to come into your office for the meeting. For clients who aren't tech savvy or who would just be more comfortable attending the meeting from an attorney's office, this is a really helpful option. When it comes to how the clients should handle the call itself, you should instruct them to call in to the meeting at least several minutes prior to the start time. If they want to, they could call in earlier or on a prior day in order to hear their trustee or a trustee ask the same questions that they're going to be asked for the most part. When they call in, they should place their phones on mute until their name is called. If it's a Chapter 13 case, they should also know that there will be other meetings assigned to the same half-hour calendar. Make sure that the clients know that the call may not have started yet. There may be another 341 taking place when they call in. A prior meeting may run over. They have not missed their meeting as long as they have the correct date, time, number, code, and they call in prior to the start time. You should instruct them to call from a quiet place, not to put their phone on hold, try not to put the phone on speaker, not to just interrupt another meeting that's going on, and make sure that they have a good internet or phone signal. If it's a joint case, each person should answer each question one after the other. And when the meetings switch over to Zoom, the client should also dress appropriately and have an appropriate background. When it comes to getting the clients to call in, as in just actually making the actual call itself, the best way to ensure they remember to call in is usually to provide numerous reminders. Our office starts with sending the client an email with the 341 notice once it's actually been set, which of course they get that same notice from the court in the mail a few days later. Then when we do the 341 prep call, we confirm that they have the correct information. We do a 341 reminder call a week prior to the meeting. We also do a text the day before the meeting and a text the day of. If the client is able to set an alarm before the meeting or a calendar reminder, that can be yet another reminder so that they call in. Time permitting, you can also call or text the client right before the meeting to remind them to call in. Attorney preparation for the 341 meeting. Most of the preparation involves preparing the client, but we do have our own prep work to do as well. The debtor's attorney will make sure that the trustee has all the correct documents and review the file to make sure they're familiar with the case. Like Maria said earlier, debtor's counsel will need to personally review the proof of identification so that they can make he or she can make the correct statements on the record. Our office has clients take a selfie holding up their photo identification so that even if we haven't met the debtor in person, or if the attorney who's handling the 341 hasn't met with the client, the attorney can still use the selfie to state that the person holding the selfie matches the ID, or if the person holding the picture matches the ID, which matches the information on the petition. Maria touched on this, but trustees also say that they appreciate when the debtor goes, when the attorney goes into this information directly after identifying herself on the record. You don't need to wait for the trustee to ask you all of these specific questions about reviewing debtor identification. Finally, the debtor also, or the debtor's attorney also needs to call into the meeting. I typically set an alarm or a calendar reminder so that I don't forget that I have to call in too. In preparation for this presentation, I asked all of the trustees and a number of debtors' attorneys what they thought was particularly helpful. It's the next slide. What they thought was particularly helpful when done correctly, or particularly derailing to the 341 when done incorrectly or not done. And for debtors' attorneys, the trustees said that having the correct domestic support information was particularly important, which has been touched on earlier in this presentation. The Chapter 7 trustees need that form filled out, the DSO form. The Chapter 13 trustees get the information directly from the petition itself, but either way, it needs to be there and it needs to be accurate. Second, having a personal injury claim or any claim, it's usually just personal injury claims that they have, but listed correctly, and knowing the law firm, the attorney the debtor is working with, and that attorney's contact information. All of that is needed so the trustees can communicate with and have special counsel appointed. The debtor's attorney should also have the debtor immediately inform special counsel of the bankruptcy, and the debtor's counsel should reach out to special counsel as well, particularly when it comes to making sure that medical creditors are listed in an asset case or a Chapter 13 case. Often the clients don't know what medical providers they owe and how much they owe, but the special counsel should have this information. This applies a little bit more to Chapter 7 cases, since the Chapter 7 trustee gets special counsel appointed and files the related motions. In the Chapter 13 cases, obviously the debtors counsel is doing this, but it's important for debtors counsel to have this information regarding special counsel either way. Finally, getting the required documents to the trustee in the required time frame is necessary, particularly getting Chapter 7 trustees the taxes at least 7 days before the first date set for the meeting of creditors. This was actually the most consistent feedback from Chapter 7 trustees for what made the 341 meeting a success or not, the taxes specifically. And of course, the Chapter 13 trustee can't hold the meeting without the necessary identification document. Next slide. All of this means that the debtor's attorney really needs to make sure to collect all of the proper documents and information before filing, not just to make sure we fulfill our legal obligations and ensure the petition is accurate, but just because debtors are so financially stressed that a lot of them seem to see the filing as kind of the end of the process. And it's great that when they file, they feel that sense of relief. We certainly want them to feel that way. But we know, and we're telling them that that is not when their work is done. But it does seem like for many clients, there's an urgency that kind of disappears after they file. Because of that, it's really helpful, necessary to get all the documents and information that we're going to need for the success of the 341 at the time of filing, because that's probably when the client is going to be most responsive. Next slide, please. A trustee's best practice for ensuring that the 341 goes smoothly is to eliminate legalese where possible so that the debtors understand the questions that they're being asked and are able to accurately respond. Sometimes it's not even legalese, sometimes it's just like a verb choice. We had a former attorney who would ask clients, did you go to credit counseling? And often they would say no, because they didn't go anywhere. So even kind of basic phrases like that can confuse debtors who are trying to pay attention and answer accurately. Another best practice for the trustees is to be on time. On the one hand, I hesitate to include this because often what causes a trustee to run behind is when they try to either accommodate a debtor who's late to the meeting, or creditors show up with questions, which isn't really something that we're able to predict. On the other hand, there are instances where calendars just start 10 to 15 minutes late, or calendars that are consistently behind. And the trustees do have more control than the debtor or the debtor's attorneys when it comes to staying on track of the entire calendar. And things just get more difficult when there's 20 people on a line, or when a debtor's attorney needs to be in a different meeting in an hour, but now their current meeting is far behind. One thing that some Chapter 7 trustees do that's really helpful is to immediately reset business and translation cases to later in the day so that their whole calendar isn't behind after that meeting. And a third best practice for trustees is to be prepared and understand the file before the meeting begins. I do want to note that this was feedback from a trustee. I did not have debtors' attorneys emailing me saying that they wish the trustees were prepared. No one said that, but obviously familiarity with the case is important in general, and it helps keep the meetings running on time. Next slide. So after the 341, hopefully the meeting is held and concluded, in which case you can proceed to the next steps for that case. For 13s, if it's a reset, you're going to want to contact the client regarding that reset and get any documents needed if it was a reset for reasons other than failure to appear. For Chapter 7s, the same would apply if it was reset. If it's continued, you're going to immediately follow up with the client to ask them for whatever is needed and continue to follow up until you get it. For both resets and continuances, you'll repeat all those reminders already discussed. And for Chapter 7 clients, it's really important to let them know that failure to attend that reset may mean that the case gets dismissed without any further notice or warning for failure to attend the reset meeting of creditors. Next slide. All right. In closing, it helps to remember that what is obvious to us as seasoned attorneys is not obvious to debtors. Reviewing the same information multiple times with the client is helpful. And it's really important to get the documents and information that you need before the case is filed, because after the case is filed, it's a little bit like it's on a conveyor belt where certain things are going to happen at certain times, regardless of preparedness. Next slide. And if everything is not in order before the case is filed, it gets messy, and we all benefit when the process goes smoothly.
I think we've run out of time. Should we continue with to allow some questions, Cece?
Hi, yes, we had a couple questions that were asked in the Q&A that I think Janine had said that she wanted to address live, but I'm not sure if she is still present. I will open it up to our panelists to address those.
I'm here.
Okay, excellent. And I see, so Janine, did you want to tackle the questions in the Q&A box? And then I see we also have another hand up from Karen King.
The Q&A box. So the question is each trustee using only one set of phone number and participation code? For Chapter 7 trustees, yes, each trustee was assigned at the outset of COVID was assigned a phone number and a leader code and a participation code. The 13 trustees, each trust operation was assigned 2 phone numbers, 2 sets. Let's see, hold on.
Great. So Nancy made a comment about people driving.
Yeah, and I wanted to say, besides being dangerous, which obviously that is, and not to just take away from the dangerousness of it, to me, it takes away from the formality and decorum of the situation. I mean, the 341 is really, really important. And one of the things I was going to mention is that almost every 727 complaint we file and every criminal referral I send up to the U.S. attorney has a mention of the debtor's testimony at a 341 meeting, the false oaths that were given. It's a really serious thing, and it needs to be taken seriously, and it's not taken seriously if you're doing it while you're driving, because the questions are important. It's important to listen to the questions, listen to the words in the questions, and give an answer. So I just think that really needs to be stressed. I would appreciate y'all stressing that.
Janine, I couldn't agree more. I had one last week where the woman clearly was driving her car. It was quite obvious she was driving her car, and I kept on asking the questions very clearly the same way I do each time. And she said, huh? And I said, ma'am, are you driving your car? And she said, yes, I'm driving my car. And it almost like she was offended at me for asking her if she was driving her car. And so, you know, coaching from the debtors bar is, I think, extraordinarily important, just to reiterate how important the process is and how important the testimony is, and making sure that they understand it. And they usually do. It's usually a one-off or that doesn't occur.
And I would say that in that situation, if it were me, and seeing as how it is the U.S. trustees meeting, the best practice for something like that would be to stop the meeting and reset it or continue it. I don't want a case where the 341 testimony is distracted testimony. And then there was a question about the videos. I assume that the debtor's attorney would be expected to appear by video. The debtors are expected to appear by video unless excused. And so I would think that the debtor's attorney likewise. But again, I'm not privy to the protocols because they're being piloted, but that would be my guess.
The materials, including this presentation, so both the slide deck and a recording of the program, will be posted to the court's website. Under the Attorney Information tab, there is a Bench and Bar Committee tab, and I included the link in the answer to one of the Q&As. If you can't see it, it should be readily available under that Bench and Bar tab. And so I would highly encourage anyone who might have missed part of it to review and to feel free to share the information, because I think there was a lot of really helpful info, tips, and practical things to know. And so with that, I see we're already almost at 1:10 and would just like to thank our panelists very much and to thank the court's IT staff also, Craig in particular for helping us get all the links set up and for getting this together as a webinar. And so with that, thank you very much. And I hope you will tune in for the next Bench and Bar Committee Lunch and Learn in a few months. So thank you all. Have a great day.